I'd like to welcome everybody to the third in this series of regular arbitration breakfast briefings. I know it's not breakfast for some of you, and we hope that you're going to find these instructive. Good morning to our friends in the UK and elsewhere in Europe. Good afternoon to those of you joining from the UAE, Africa and Mauritius, and good evening to those of you in Singapore and elsewhere in the Asia-Pacific region. With me today are my colleagues Jaiwei Lee and Jamie Holmes, who form part of the Wilberforce Chambers arbitration team. Now, the title we've given to today's briefing is Conflicts, Bias and Disclosure Duties. Where are we now? And let me take a moment to explain what we're going to be doing. First of all, most of you will be aware of the Supreme Court's decision in Halliburton and Chubb, which concerned questions of conflicts of interest, bias and disclosure duties in relation to an arbitrator. There have been several webinars by others on this subject and a large volume of articles. So what we do not want to do today is to repeat everything which has been said and written about the case. One commentator, who will be nameless, described the case as the most significant decision in English arbitration law for a decade. What we want to do today is in fact to question the significance of Halliburton in the context of international commercial arbitration and to approach the decision from a somewhat different angle to the commentaries to date. The judgment came more than a year after the oral argument had taken place, and the question that we're really going to be asking is whether Halliburton in the international context was actually worth the wait. The second area that we're going to be talking about today is the Court of Appeal decision on the 11th of January this year in a case called Secretariat Consulting. It concerned the duties not of an arbitrator but of an expert witness in arbitration proceedings. But it has similarities in terms of the English court's approach towards conflicts of interest in Halliburton. Secretariat could really justify a breakfast briefing on its own, but for today's talk we're really going to talk about it only to draw parallels with the court's approach in Halliburton towards arbitrators. We're very keen, as we always are, that there should be an exchange of views, so we welcome your contributions. Please use the question and answer buttons at the bottom of your screen rather than the chat button to ask questions as we go along. And we will very happily try to deal with them in the course of the discussion. And finally, for light entertainment, we have two polls during the course of the discussion on Halliburton, from which we are interested to get your own instinctive views on the questions which we are going to be asking. So let's start with a very brief look at the facts of Halliburton. The case concerned one of several insurance claims brought by insured against insurers under a Bermuda form liability policy. The claim arose out of the damage caused by the explosion and fire on the Deepwater Horizon drilling rig in the Gulf of Mexico as long ago as 2010. And in accordance with the dispute resolution provisions in the policy, the English High Court appointed as the presiding arbitrator Mr. Kenneth Rockerson QC, an arbitrator who the Supreme Court rightly described as having a long-established reputation for integrity and impartiality. Now, prior to his appointment, Mr. Rockerson had disclosed to Halliburton and the court that he'd previously acted as an arbitrator in arbitrations to which Chubb was a party, including as a party-nominated arbitrator appointed by Chubb, and that he was currently involved in two pending arbitrations involving Chubb. But he didn't disclose to Halliburton his proposed nomination by Chubb as an arbitrator in a subsequent arbitration concerning an excess liability claim arising out of the same incident brought against Chubb by Transocean, who were the rig's owners, under another Bermuda form policy, or his acceptance of an appointment as a substitute arbitrator on the joint nomination of the parties in a claim made by Transocean against another insurers on the same excess layer. And in those circumstances, Halliburton sought the removal of the arbitrator under section 24(1)A of the Arbitration Act 1996 on the ground that circumstances existed that gave rise to justifiable doubts as to his impartiality.
Well, thank you, Stuart. I'm going to pick things up there. Now, as Stuart has said, there have been a lot of webinars on Halliburton, and what we want to offer you is something a little bit different. I'm going to first set out a few more reminders and signposts, and then we are each going to take you through the three key parts of the decision by way of our analysis of whether it was worth the wait. Now, as we said, we're hoping this will be interactive, so do jump in with any comments and questions. So just to give you a little bit of further background, and by way of reminder, there were three relevant arbitrations, with there being one common party, Chubb, to all three. And the claim by Halliburton concerned the first in time of the three arbitrations. The leading judgment of the Supreme Court, with which all other members of the court agreed, was given by Lord Hodge. Lady Arden also gave a separate concurring judgment. There are some differences between the two, but the clear ratio is Hodge's majority judgment. And so, save on a few points of detail we're going to cover across this session, we don't propose to take you through the differences. And the final point to flag, just by way of a reminder, is that the claim brought by Halliburton in the English High Court was to remove the arbitrator in the first arbitration, Mr. Rockerson, on the basis of apparent bias, or, as the Supreme Court summarised it, real doubts as to his impartiality. And that was on the basis of his acceptance of the appointments in the second and third arbitration, his failure to give disclosure of the circumstances, so as to allow Halliburton an opportunity to object to his appointments in the second and third arbitration, and also that he'd offered to resign from arbitration 1, but that Chubb had refused to let him. And just by a bit of way of signposting, we consider the three key stages in the Supreme Court's analysis to be as follows. First, is there a duty of disclosure? Was there a duty upon the arbitrator in the second and third arbitrations to give disclosure to Halliburton in the first arbitration? And what was the scope of that duty? And what the Supreme Court held is that there generally, as a matter of English law, was such a duty of disclosure, and that it had been breached in this case. That, however, did not necessarily mean that there was an appearance of bias as to justify removal. You have to move on to the next stage of the analysis. But before you get to the duty of fairness and impartiality itself, there was a second stage of the analysis, and that's how the duty of disclosure interacts with the duty of confidence and privacy that the arbitrator owes in the context of an arbitration. To what extent could the arbitrator make any such disclosure in arbitration 1 without first obtaining the express consent of the parties to arbitration 2 and 3? And what the Supreme Court held there was that the duty of confidence was such that express consent would be required for some disclosure, but not other forms of disclosure. And in this case, all of the disclosure as should have been given, but wasn't, could have been given without express consent. So there was that didn't then ultimately factor into the outcome of the case. They didn't need to consider it much further. Third, you then move on, as I say, to the final stage, which is, was there apparent bias? Or to put it the other way around, the duty of fairness and impartiality. And so the question is, to the extent that the duty of disclosure has been breached, did that give rise to an appearance of bias, such as to justify the arbitrator's removal? As I say, that being the relief that Halliburton had sought. And the Supreme Court held that there was not an appearance of bias such to justify removal, and so the claim failed and the appeal failed. And with that, I'm going to hand you over to one of our excellent junior tenants, who I hope many of you will have already heard from at our second international arbitration briefing, Jai Wei, who's going to start to unpick some of this. Although I think he's on mute.
Sorry, I'm on mute. It's an amateur error. So, thanks very much, Jamie. That was a quick whistle-stop tour of the facts and the decision in question. And while the decision sets out many general principles that may appear to be of wider practical significance, what we want to try to do is put it in context. And I think you'll find that when you do that, the decision in question can be confined to its very particular circumstances. For one, the ratio of the case was a very narrow one. For it to directly bind the parties to the subsequent cases, you'll need an arbitration where the express terms of the contract are silent on issues of confidentiality, of disclosure, and impartiality. Then you'll secondly need to make sure that there are no other institutional rules that apply. And that will be quite rare, of course, because it just so happened in this case that the Bermuda form arbitration didn't entail the application of particular institutional rules, but that's relatively rare. And last of all, you need the seat to be of the arbitration to be in England. And that's because some of the Supreme Court's analysis, notably the test for apparent bias, is rooted in very well-established English case law, and other jurisdictions might take a different approach. Indeed, the submissions that were made before the Supreme Court by the various institutions that put in submissions, including the ICC, the LCIA, and the LMAA, show that there isn't a consensus across all institutions on these issues, and that might very well be the same with seats. Furthermore, this is quite a narrow decision to begin with. We need to take into account what we might term judicial realism. Because one is looking at this as a judge. By the time the matter had reached the Supreme Court, it was a very unattractive challenge, however sincerely held the position was by the claimants to begin with. The issue was first discovered in November 2016, and the claim issued by Halliburton in December 2016. The claim was then heard by Mr. Justice Popplewell in January 2017, and judgment handed down in February 2017. And all while this was going on, the merits hearing was taking place. So whilst Halliburton appealed, the tribunal nevertheless decided in favor of Chubb by giving an award in December 2017. So once the matter had appeared before the Supreme Court in November 2019, Halliburton looked like it was trying to take a second bite of the cherry. It looked like they'd taken part in substantive proceedings already, but lost in the merits and wanted a retrial. And this is a point we'll return to, but it shows that timing was probably a very decisive factor in the Supreme Court giving judgment as it did. So in many ways, this was a case which turned on its particular facts and circumstances. I think the Supreme Court was clear that the three key stages of analysis that Jamie set out earlier, disclosure, confidentiality, and impartiality, turned on the specific terms of the contract, the institutional rules that may have been incorporated by reference, and what the parties' expectations were taken to be as part of this factual matrix and shared understanding in light of arbitration custom and practice. The point is that different institutions and different parties will take different views in different circumstances about whether it's typical or desirable for the same arbitrator to be appointed across multiple arbitrations concerning the same underlying events, like a natural disaster or a shipping incident. Moreover, it will be apparent from the Supreme Court's analysis on the duty of impartiality that this point turns very heavily on the facts and the procedure that will unfold in any particular case. And so for these reasons, I think the decision in Halliburton and Chubb, while looking like a decision of fairly wide significance, is in fact one that can be confined to its very particular facts.
So drawing all that together, the Supreme Court is unlikely, its decision is unlikely to be more than of limited assistance as a directly binding precedent. And we want to offer a prediction, which is that Halliburton's going to be cited in everything, in common law courts across the world, but will be able to be relatively easily distinguished by a court which is minded to do so. Indeed, it seems to us that most of what the Supreme Court decided will, at least in most cases, be largely academic, even if it might be very persuasively so. Just to give 2 points. First of all, as we said, the Supreme Court was clear that all three of the key stages turned on the particular Bermuda form contract. And in most cases, institutional rules or express terms in an ad hoc arbitration agreement are going to cover this already. And also, second, in institutional arbitrations, the duty to make disclosure really is nothing new. And similarly, there will usually be provision to cover both the duty of confidentiality and the duties of impartiality and fairness. Just to give one illustration of that, new Article 17.2 of the ICC 2021 rules, it provides that the arbitral tribunal may, once constituted, and after it has afforded an opportunity to the parties to comment in writing within a suitable period of time, take any measure necessary to avoid a conflict of interest of an arbitrator arising from a change in party representation, including the exclusion of new party representatives from participating in whole or in part in the arbitral proceedings. And that provision was in part introduced to stop parties, often the respondents, playing games in terms of trying to get an arbitrator off the tribunal by appointing counsel who were too close to him. And it remains to be seen how Article 17.2 and similar rules in other institutional rules are going to play out in the future. Jamie.
Thank you, Stuart. Now, you might ask yourself, well, even if the institutional rules that apply in my arbitration, or indeed the express terms of my contract, already address each of these three key stages or a combination of them, does what the Supreme Court has set out, at least where English law is your curial law, provide a base, or English law governs the contract, provide a baseline minimum standard that the parties cannot contract below? And there are two answers to this point to bear in mind. The first is that the Supreme Court said no, at least as regards some of the stages of analysis. It was very clear that it didn't consider there to be a baseline minimum on the duty of disclosure. It was very clear that in some areas of international arbitration, the parties' shared understanding in light of practice and custom in that area was going to be, or most likely would be, as I suppose it would still turn case to case, that there was no duty to give such disclosure at all. Now, as I say, that's the first answer, but just query there whether the same approach would be taken on the duty of impartiality and fairness. I think it's possible to imagine the parties drafting, say, an express clause where there's no institutional rules apply, that they had agreed upon as to what the duty of impartiality was in that particular case, how it was going to work, or what its content was, that the court found itself slightly ill at ease with, in the sense that it felt really something had happened that was beyond the pale, but the contract, the express terms of the contract allowed it. Query if the court, an English court, would be minded to say, well, I actually think that there's still a possibility for removal here. It's not immediately obvious how the English court would have wiggle room to backpedal to this after the approach in Halliburton, which very much focuses on the parties' contract. But perhaps, well, it's one that we'll have to see going forwards. Now, as I said, there are two parts to the answer, and the first is that the Supreme Court said no, that we aren't providing a baseline standard, at least on the duty of disclosure. The second half of the answer is one that Stuart has already given, which is that most institutional rules, at least where they apply, tend to apply, not only already deal with this, but tend to apply a higher standard than the one the Supreme Court itself imposed. So to take again disclosure as the example, the Supreme Court's set out the baseline test as a matter of the English general law, where there's no express term covering this, is that the duty was an objective one, and you need to give disclosure of facts that would or might lead the fair-minded, informed observer, having considered the facts, to conclude there was a real possibility of bias. By contrast, and this is going to be a slight melding of their various different terms, the ICC, LCIA rules, and also the IBA guidelines set out a subjective test. You have to give disclosure of facts and circumstances that may, in the eyes of the parties, give rise to reasonable or justifiable, as I say, the wording's slightly different, doubts about the arbitrator's independence and impartiality. And it seems to me that that is a higher test, in the sense that it's likely to lead generally to more disclosure being given than the test the Supreme Court set out. So bringing that together, we asked, what has the Supreme Court decided that will not, at least in most cases going forwards, be other than academic? And our answer is that what it sets out as to the content of English general law and the default of the parties' contracts covering this will generally be covered in most parties' contracts. And it hasn't, at least generally, set a minimum standard, as you can contract out of it. And what the Supreme Court has generally set is a lower bar than what most institutional rules already provide for. And with that, I'll hand you back to Jarway.
What we've covered so far, and I hope my mic is on, yes it is the issues that the Supreme Court has decided. And I want to touch on what questions the Supreme Court hasn't decided, because unsurprisingly, as with any appeal or indeed any case, there are always going to be a number of matters that remain unresolved. And what is clear upon reading the judgments in Halliburton is that there are a number of, I want to say, big questions that still need to be properly answered and developed in subsequent case law. Just to give two examples of this, one question that remained unresolved is to what extent and in what circumstances does the mere fact of non-disclosure of a relevant or disclosable matter give rise to a sufficient appearance of bias so as to justify removal? Put it this way, I think that the issues in this question become a little bit circular. On the one hand, you've got the UKSC saying the duty to disclose will only extend to facts which the fair-minded observer would lead the fair-minded observer to conclude that there was a real possibility of bias. And then you have at the same time a finding that a failure to disclose facts which might lead to a conclusion that there was a real possibility of bias might on its own be evidence of that bias. So this sort of illustrates, I think, that there is always going to be an inherent link between the contents of the duty of disclosure, the time when it arises, and the duty of impartiality itself. And we can see the reason for this very close linkage in the Supreme Court's findings. Lord Hodge, who was speaking for the majority, concluded that the duty of disclosure arose by being implied, in effect, into the terms of the parties' contract, because there was already a duty of impartiality incorporated into that same contract by Section 33 of the English Arbitration Act 1996. Lady Arden, in a separate concurring judgment, went even further. She said that there was no discrete or independent freestanding duty to disclose at all on a proper analysis, and that, in fact, this so-called duty of disclosure was really just an incident of the primary duty to act fairly and impartially. What the Supreme Court was therefore clear about when it came to the breach of duty of disclosure is that a breach of that duty, even if accidental, can itself be a factor in whether there was an appearance of bias, but perhaps somewhat hedging itself. It was also clear that there would be many cases where this carried little to no weight whatsoever. And that was certainly the case in this one, in Halliburton itself, because the outcome was that a breach of the duty to disclose wasn't sufficient to create an appearance of bias justifying removal. The implication of all this is that the breach of a duty of disclosure will only be relevant in a marginal case where there's already a prima facie case of bias to answer, such that the breach of the duty of disclosure tips it over the edge. But the Supreme Court decision doesn't spell this out, and we'll have to see how this dynamic plays out in future cases. Another unresolved question is this: to what extent is an arbitrator under a duty to make enquiries as part of their obligation to give disclosure? Or to put it another way, to what extent will they have constructive knowledge of matters that they could easily or reasonably or with reasonable diligence have discovered? The question didn't arise in Halliburton, but one can easily imagine a case where there are various interests between group companies, one of which is another arbitration that they're sitting in. And it's not clear whether in these circumstances the arbitrator would have a duty to make reasonable inquiries about these linkages, or indeed whether a failure to do so would amount of a breach of the duty to disclose. So that's another big question that will have to await decision in future litigation.
So just to recap on what we've been listening to, so far we've been focusing on the limits of what the Supreme Court has and has not decided. But I want to move on now to consider the extent to which the reasoning of the Supreme Court on some of what it's decided is satisfactory and either will or won't operate as a useful guide going forwards. I'm going to focus on perhaps the most interesting and potentially most difficult of the three key stages in the Supreme Court's analysis, namely the second, how the duty to disclose interacts with the duty of confidentiality. The potential difficulty is that the duty of disclosure requires the arbitrator to disclose certain information to the parties to the first arbitration, which is confidential to the parties to the second. So the arbitrator's various contractual duties appear to be pulling in opposite directions. We suggest it's unsatisfactory that the Supreme Court's analysis places so much emphasis on inferred consent to disclosure in the form of waiver, which potentially has a very broad ambit in future cases, rather than taking a more orthodox analysis on the basis of express or implied contractual terms. And we're going to unpack and explain that as best we can. The Supreme Court starts its analysis very clearly. The duty of confidentiality isn't absolute. and what its precise boundaries are remain unclear. But the court was assuming that both duties are prima facie engaged and can't be sidestepped. The need for disclosure in Arbitration 1 and the duty of confidentiality in Arbitration 2. And the Supreme Court was clear. If the arbitrator cannot give disclosure in Arbitration 1 in the manner that complies with the duty of confidentiality in Arbitration 2, then he or she will have to decline to act in the second arbitration. However, it may be that the arbitrator doesn't need express consent from the parties to Arbitration 2 to provide the information that he or she needs to satisfy the duty of disclosure in Arbitration 1.
Thanks, Stuart. I'm going to continue to unpack this point a little bit. So what the arbitrator needs to disclose will vary from arbitration to arbitration. That links back to what Jarwe was already saying about the fact that the content of the duty depends on the facts or circumstances that have given rise to the possible appearance of bias. So in some arbitrations, or some circumstances, it may be that very little, if any, disclosure is needed. As I also said previously, the practice and custom in some areas may mean that none is needed. But by contrast, it may mean that quite a lot of disclosure is needed. And as Stuart has already said, the Supreme Court considered that some disclosure can be given without the need for express consent. So just tying those points together, if you're in circumstances where you need to give quite a lot of disclosure, you may find it more difficult to fall within the bracket of matters that can be disclosed without express consent. And therefore, you are going to need to get express consent to give all of the disclosure that you need to give. Otherwise, you're going to have to withdraw. If by contrast, you only need to give relatively minimal disclosure, it may mean that you don't need to give, you don't need to obtain any express consent, and the problem largely falls away. And that's what the Supreme Court found in Halliburton itself. And it's the way that the Supreme Court got to that conclusion, doctrinally, if I can put it that way, that we think is somewhat unsatisfactory. It starts very clearly in a very orthodox fashion. Whether an arbitrator can make disclosure of an existing or prospective arbitration without first obtaining the express consent of all parties to the arbitration about which disclosure right requires to be made will depend upon the relevant arbitration agreement and the custom and practice in the relevant field. So far, so good. That sounds like the focus is on the express implied terms of the contracts and what the parties' shared understanding is to be taken in light of custom and practice. And so where it's going is saying that the reason you don't have to give or obtain express consent is because that's what the terms of the parties' contract says. You've implied that into the content of the duty. You've said that the parties are arbitrating in an area where typically this kind of disclosure is given. So that's what it's been understood that they have agreed, that the duty of confidentiality doesn't bite, or itself, the exception is built into the contract. However, almost all of the focus of the Supreme Court's analysis is then on whether such consent can be inferred, and it uses that word over and over again, such that it can be said that there has been a waiver of the duty. Now, this implies that the parties' contract actually did require consent, that there has been a breach and that it's been waived, or at very least that the duty in the first place has been waived, even if there hasn't been a breach. And the Supreme Court was explicit that such a waiver can be inferred from the parties' conduct. In one instance, it refers to the nomination of an arbitrator common to both arbitrations. In circumstances where you are yourself a party to both arbitrations, might in some circumstances by itself allow the court to infer that you consent to such information being provided. And that may be true on the facts of some cases, but it seems to me to be far from a general proposition that one can simply state as being universally correct. It also saw such consent or waiver as being capable of being inferred from the terms of the agreement, the applicable institutional rules, and or custom and practice, as I referred to. Now, this is unsatisfactory at a doctrinal level, as it's not entirely clear why the terms of the contract itself, including institutional rules as may have been incorporated into them, or custom practice, as is said to form part of the parties' shared understanding and how the contract is to be read and understood, would give rise to a waiver at a later point in time when this need for disclosure arises. Waiver is usually a matter of acts, omissions, or representations, like other species of estoppel. But more importantly, it's undesirable. The concept of an inferred waiver is much more slippery and broader. It gives courts in future cases a really very broad remit to say, well, I think on the facts of this case, I can infer a waiver from that, and therefore I can reach the conclusion that I want to reach, whatever that might be. Whereas if the court is forced to reach its conclusion as to, on the basis, can say, well, actually looking at this contract, there's the scope of the express term, or I'm going to imply a term in that there's no need for express consent here, because that is the scope of the duty of confidentiality in that contract. And it doesn't need to get into this much slippery idea of an inferred waiver. And what this all comes back to is, as I say, the latitude that a court has in future cases to find one way or another. In our submission, it would have been much better, and as a matter of regret, the Supreme Court didn't confine itself to the express implied terms of the contract and the very familiar concepts that apply to that. And just as a final note here, Lady Arden, in her concurring speech, notably is clear and went out of her way to say that she considers that the Supreme Court has not created any new exception to confidentiality here, as it all turns on the terms of the contract. Well, to the extent that she has adopted the analysis I just set out about express implied terms, then we agree. But she too, like Lord Hodge in giving the judgment of the majority, refers on occasion to waiver and whether a party can be taken to have consented. So she seems to have ultimately adopted the same analysis as Lord Hodge, which is unsurprising as she agrees with his speech. And if so, then we're not so sure that we do agree with her entirely when she says that no new exception has been created. Now, whilst there is nothing new to find that a contractual duty can be waived in particular circumstances, it seems to have potentially rather expanded the scope for that in future cases, and thereby at least somewhat potentially eroded the duty of confidentiality. With that, I'm going to hand over again to Jaiwei.
So far, we've been talking about the limits of the Supreme Court's decision in Halliburton and what we think it got wrong. I want to shift gears a bit and now talk about some tactical issues that Halliburton prompts us to think about. And the big thing that I mentioned earlier is timing. Because we go back and look at the Supreme Court's specific analysis, it becomes apparent that timing was decisive in many ways. And in part, timing arises as a factor because the breaches of the duties of disclosure and impartiality differ at the point at which they're assessed. The disclosure duty comes into play at the time of the event which gives rise to the apparent bias. So, for instance, if that event is the appointment to a second arbitration, then the duty to disclose arises once it becomes apparent that he will be so appointed. But if, like in Halliburton, the claimants are seeking removal, just breaching the duty to disclose is not enough. You need to show that this justifies a separate finding, that there's been a breach of the duty of impartiality that justifies removal. And on that point, the Supreme Court concluded that the breach of any duty of impartiality is to be assessed at the time that the removal application is heard. And the result in Halliburton of this difference in timing was that events had moved on so far by the time the case was heard that the Supreme Court simply couldn't find that apparent bias was such as to justify removal. And in that regard, timing was key to the outcome of the case. There's a quotation from the Supreme Court itself that I'm going to try to pop on the chat here. I'm not going to read it out in full, but it offers a tantalizing view, I think, of how timing questions would have changed the outcome, I think, in the Halliburton case. And so our tactical suggestion in light of this is that if your goal is to give yourself the best chance of removing the arbitrator, then get that application off as soon as possible in terms of issuing. And indeed, if the intent is to avoid the outcome in Halliburton, then query whether or not you might want to seek an interim injunction to stop the clock, to avoid this finding that your subsequent attempt to remove the arbitrator is regarded as opportunistic or tactical to get a second bite of the cherry. Stuart, still on mute.
Sorry, just having a little trouble unmuting myself. So finally and briefly, although it's an important potential observation, as to what we all mean by bias. There are at least two types of bias in play here, and the Supreme Court refers to both. I'm not talking about actual bias as opposed to apparent bias, but that's an even more important distinction. Rather, I'm referring to two slightly different circumstances that each might give rise to apparent bias. The first is where the arbitrator is seen to be too close to one of the parties, such that it might be more likely that another person to decide the case in their favour, whatever the facts or the evidence or the legal argument may be. And we might call that bias towards a party per se. But the second is where the arbitrator is seen as potentially having preconceived judgments or notions of what the correct outcome is on the facts or evidence or legal submissions. In other words, they're prejudiced in a more strict sense of the word, such as to potentially affect the outcome. And it may be that the second of those two is more important than the first. And that's where potential unfairness comes in. The Supreme Court accepted that parties consider there to be an advantage in that the party who is the common party to both of two or more arbitrations can see how the common arbitrator is reacting to evidence and submissions and gaining an insight. And that's certainly not something to dismiss, but experience, I think both personally in my case and generally, suggests that what one can accurately divine and how useful that information varies from tribunal to tribunal. Parties certainly always consider it useful, and that might be enough to give rise to sufficient appearance of an unfair advantage or inequality of arms. But it seems to us that the greater concern is that the arbitrator has actually formed a view on the outcome, or begun to do so, perhaps even at a subconscious level, in the light of the way the arguments are being put. Now, we've been talking for about 35 minutes. It's time to have our two polls for this session, and perhaps we can put the polls up on the screen. The first question: was the Supreme Court right not to remove the arbitrator for apparent bias? That's a sort of fairly standard question that's arisen in webinars of this kind, and we await your answer. I'll come on to the second question in a moment. So please vote on this. So 2/3 think that the Supreme Court was right not to remove the arbitrator for apparent bias. 36% think that they were wrong. That then leads me on to the second question, which is obviously impacted on by the answer to the first. But the second question now coming up on the screen: would the Supreme Court have reached a different conclusion if the arbitrator had been less prominent than Ken Rockerson? Now, we asked that for the cynics in the audience, and somewhat tongue-in-cheek. Let me see what your answers are, and then I'll just make a short comment on it. Well, again, a much closer result. Nearly a small majority in favour of the Supreme Court having reached a different decision if Ken Rockerson had not been the arbitrator. And that's interesting. I can assure you that all your answers are entirely anonymous, as opposed to anything that Jai, or Jamie or I may be saying. But there was a general perception in the arbitration community that if it hadn't been Ken Rockerson or somebody of equal prominence, the arbitrator might have been removed. Now, thank you for that. Moving on, there's a number of other interesting points that emerge from Halliburton. There's not time to discuss them all here, but we're going to mention one of them, or Jai is going to mention one of them, namely the issue of the personal liability of arbitrators, an aspect very close to the heart of myself and others. Jai.
Halliburton itself, this wasn't a question because the claimants didn't seek any other relief apart from removal, but what if Halliburton itself had sought other relief? And the Supreme Court here said a number of different things, obiter, of course. Lord Hodge questioned whether or not there was a basis in English law for damages absent bad faith, but he also alluded to the possibility that the arbitrator might be liable for costs in the event of a failure to make timely disclosure, if that disclosure then led to an investigation which concluded there was no need for removal. The idea being that his failure to give disclosure was what caused these wasted costs to be incurred. Lady Arden, on the other hand, I think reached a slightly different conclusion by suggesting that actually ordinary consequences for breach of contract would follow, although she didn't specify whether or not damages would be nominal or if there would be an equivalent outcome to varying wasted costs. Now, if we draw these threads together, an arbitrator may not find very much comfort in Lord Hodges' comment that damages are unlikely absent bad faith, given that he may very well still be liable for substantial costs, and in light of Lady Arden's alternative finding, I think that breach of a contract can entail the usual contractual remedies. We should say, of course, that with everything else covered in this talk, this is all subject to the terms of the contract, and many institutional rules do provide protection for arbitrators, and we can expect the express terms of many contracts to do so as well. So perhaps the question of personal liability is somewhat more illusory than real, but that's something worth bearing in mind if the express terms of the contract don't provide the arbitrator with this sort of protection.
We've got one question from the audience. Let me deal with it now before we move on to Secretariat. The question is the practical point for arbitrators that they should be very cautious in assuming that there's been an inferred waiver of the duty of confidentiality where there are no express terms? Well, thank you for the question. It's very pertinent from a practical viewpoint, and my own view, or I don't know whether Jai Wei or Jamie may have a different view. My own view is that the answer is certainly yes, and in all cases where you're dealing with an inference of anything, be it waiver or anything else, there is a particular need to exercise caution. I think one practical thing that comes out of Halliburton is that arbitrators generally will be looking very carefully at their obligations, irrespective of whether Halliburton is per se applicable or not. I don't know whether Jai Wei or Jamie want to add anything, otherwise we'll move on, I think, to Secretariat.
No, just to chip in on my part, I mean, I think that's got to be right, Stuart. The extra slippery factor on top of that is and this may be difficult for you to work out as the arbitrator standing in the position you're in, but how much you need, how easy it's going to be to fall within the inferred waiver is going to depend on how much you need to disclose. And how much you need to disclose is going to depend on what the circumstances are that give rise to the appearance of bias. If essentially, sort of, if I can put it slightly, perhaps unkindly or inelegantly, how smelly is the situation? If it's very smelly, then you might have to give quite a lot of disclosure to clear the air. Whereas if it's not very smelly, it might be just a very, very small amount of disclosure is necessary, and you're going to find it much easier. So I think that's just the further point to bear in mind. What Stuart, I agree with everything Stuart said, but it's inherently linked to how much disclosure you need to give in the first place. All
right. Well, Andrew, I hope that goes some way towards answering your question. If not, please feel free to follow up after the seminar. Let's move on to Secretariat because time is running short. Like Halliburton, the case concerned the role of a participant in international arbitration who was not a party to the proceedings. In Halliburton, it was an arbitrator. In Secretariat, it was a party-appointed expert witness. In Halliburton, as we've seen, the arbitrator was not removed because it was found that there was no apparent bias. In Secretariat, the expert was injuncted from continuing to act in the second arbitration. And in both cases, the contractual framework in which the person in question was appointed was in play.
Now, in brief, the facts of Secretariat were as follows, and I apologise to Ben and Rebecca, who are both on the call on this webinar, if they think I'm doing their case a great injustice. Now, again, there were multiple arbitrations. Here there were two, and again, there's an overlap of one common party whose name is anonymised, and so I'm going to refer to them as the common party or the claimant, as they are the one that ultimately made an application to the English High Court, which led to the appeal, and they were the claimant in that. And it again concerned an overarching event. It wasn't a disaster such as the Deepwater Horizon event, but it was a common project to design a petrochemical plant. And in the first arbitration, the common party or the claimant in the High Court was actually the respondent to that arbitration. The claimant was the claimant in the High Court claim was the head developer of this project, and they were being sued by one of their subcontractors. The main element of the first arbitration was additional costs of part of the works due to delay and disruption. And the subcontractor said that this had been caused by the late release of certain design drawings. And in this arbitration, the common party or the claimant hired the first defendant in the High Court action as an expert and to provide litigation support services. So that's arbitration 1. In arbitration 2, again, the common party or the claimant in the High Court was the respondent. They were being sued by somebody else this time. And this was their more immediate subcontractor who was responsible for the design drawings in issue in the first arbitration. This more immediate contractor was claiming unpaid fees, some of which the common party or claimant in the High Court had disallowed due to the delay in the design drawings having been released. And they had counterclaimed back in light of those delays, amongst other things. And in this second arbitration, it was the more immediate subcontractor who hired the second defendant to act as an expert for them. You've got in the second arbitration, the second defendant, an entity in the same group as the first defendant, acting as expert and part of the support team for the party bringing the arbitration against the claimant in the English High Court. Whereas in the first arbitration, you've got first defendant acting for that party. And I apologize, this can all get a little bit confusing as so many of the names have been anonymized. But in a nutshell, D1 is the claimant's expert in the first arbitration, whereas D2 was acting against the claimant in the second arbitration. And just as a point of detail, there were no common arbitrators. It doesn't raise some of the same issues as Halliburton in that sense. The claimant obtained an ex parte injunction from the English High Court, first instance, to stop the second defendant acting in that second arbitration. When this went up to the Court of Appeal, there were 4 issues. First, did the first defendant, who had the direct contract with the claimant, owe a fiduciary of loyalty to them, as the first instance judge had held in forming the basis of the cause of action for the interim injunction. The Court of Appeal ultimately held no, it didn't need to decide that. If not, did the first defendant owe a contractual duty to the claimant to avoid conflicts of interest? And the Court of Appeal said yes, it did, and that was partly why it held it didn't need to get into the fiduciary duty question. If so, did that contractual duty between the claimant and the first defendant extend to the second defendant, who, remember, is the one acting in the second arbitration, as well as the third defendant, for reasons that the Court of Appeal didn't seem to really understand, and I don't understand either, but somehow a third entity in the group had also managed to involve itself in the correspondence. And finally, was there a conflict of interest, such as to result in a breach of the term of that contract and therefore ground the cause of action for the interim injunction? And I'm now going to hand back to Stuart, who's going to get a bit more stuck into the analysis.
Well, I'm not going to consider the fiduciary duty issue. That's for another day. And the first instance judge and the Court of Appeal differed on that. Rather, I'm going to focus, given that we've been talking about Halliburton, on the conflict of interest issues. The Court of Appeal decided that SCL did owe a contractual duty to the contractor to avoid conflicts of interest, which did extend to SIUL, and that there was a conflict of interest as a result of SCL's engagement in the first arbitration and SIUL's engagement in the second arbitration. Whereas in Halliburton, the court stated that as a matter of plain English law, there was a legal duty of disclosure on an arbitrator. In Secretariat, the court stated that the duty to avoid conflicts, which extended to SIUL, arose as a matter of the contractual terms of engagement between the contractor and SCL. Both Halliburton and Secretariat recognised the ability of parties to modify the common law duty of disclosure and the duty to avoid conflicts by agreement, and also the potential inapplicability or modification of those duties in specialist areas where there was a limited pool of arbitrators or of experts, for example, delay and quantum experts in the construction sector, as the case might be. The decisions in both cases contain useful discussions of the principles involved, but they each turned in their own way on their specific facts. The existence of a conflict of interest is a matter of degree. And in Secretariat, the expert could only act in one of the two arbitrations, but in Halliburton, the arbitrator was not constrained from acting in multiple arbitrations. One important tangential point, if I may, in both cases, the appellate court decided that there was no good reason why the identity of the arbitrator in the former and the expert in the latter should not be made public. Neither was a party to the arbitration proceedings, and arbitral confidentiality didn't apply to them, and open justice required that they should be identified.
From our perspective, there are two especially interesting issues arising from the Court of Appeal's analysis in Secretariat. Issue one is this: the expert was assumed, it seems, at least in most cases, to be a part of the legal team. That doesn't mean that the expert is partisan per se, and that they still owe overriding duties to the court, but they're clearly very different to arbitrators. And this issue arises in one of the main lines of arguments run by the defendants in the case. What was the conflict, they said, given that the expert will ultimately give the same evidence in both arbitrations pursuant to their duty to the court, and there is no property in a witness? The answer the Court of Appeal gave seemed to be that this all turned on the facts of the case, and in this particular case, the expert was performing a far wider role than simply giving evidence. They formed an important part of the support team, as delay and quantum experts usually do in these arbitrations. Perhaps more interestingly is that there is a wider implication in the judgment that the Court of Appeal seemed to consider it true that most experts in most cases would be non-partisan in this very loose sense, albeit as a matter of degree, and that some cases an expert may be such an expert on a discrete part of the team that they don't form part of the wider team. Another interesting point that arose in Secretariat was this: how were the second and third defendants bound by the terms of the first defendant's contract with the claimant? As we've said, the Court of Appeal decided this entire case on the terms of the contract. There was just no piercing of the corporate veil. And yet, despite that, there wasn't any finding that the second and third defendants were party to the whole contract between the first defendant and the claimant. In fact, the second and third defendants' commitment was only limited to a specific and particular undertaking with respect to conflicts of interest. So it looked a bit like what the Court of Appeal was doing was carving out this discrete contract of its own, the burden of which applied to both the second and third defendants as much as it did to the first defendant. In one sense, it looks a bit like a jurisdiction or arbitration clause almost, in that it's treated as its own freestanding discrete contract. Because if any other finding were to follow, that would seem to be the Court of Appeal saying that the burden of the contract falls on two non-parties, which I think would be quite a radical development in English contract law.
So, where are we? To round off the discussion today, was the Supreme Court's decision in Halliburton worth the wait? We suggest that the answer is a qualified yes. On the plus side, the decision undoubtedly provides important clarification on a number of aspects of the law relating to an arbitrator's duty of disclosure. It contains a valuable, if not exhaustive, review of various international comparators and the customs and practices of several arbitral institutions and the sectors which they serve. And it demonstrates the strong support of the English courts towards arbitration in England. And as I said earlier, it will without doubt be considered in other common law jurisdictions. On the minus side, despite that comprehensive analysis, we suggest that the positive impact of the decision may in practice be limited. First of all, arbitrators almost invariably err on the side of caution when considering the making of any disclosures. That goes back to the point that Andrew touched on in his question in the Q&A. Although the decision may lead prospective arbitrators to agonize more when deciding whether and if so what matters to disclose. So too do the arbitral institutions adopt a cautious approach when deciding whether or not to make appointments in the light of any disclosures made. The disclosure requirements are in fact stricter, as we've seen, than those required under English law. And while the disclosure obligations in respect of Bermuda form arbitrations are now clear, whether or not, even in that context, they've been breached will remain fact-specific. The Halliburton decision also leaves open the position in respect of other ad hoc arbitrations and expands the scope for potential challenges to the appointment of arbitrators. A recent trend is challenges to arbitral appointments, often unmeritorious, and Halliburton may provide fertile ground for that trend to continue. And in that respect, it's reassuring, I think, that the Supreme Court was astute to note that the objective observer is alive to the possibility of opportunistic or tactical challenges. So, in conclusion, we welcome any thoughts and comments that you may have, and particularly any suggestions you may have for further briefings. We hope you found this one useful. And I would urge you to leave feedback on the post-webinar questionnaire, please, which is going to appear in your browser shortly. And that's really important for us to know how we can best serve you. The recording is going to be available to view on the YouTube channel later this week, in case you missed any of the session. And our previous breakfast briefings from the last 2 months are also available there. Now, looking forward, next month's arbitration briefing, when Bobby Friedman and James Wormsley and I will be discussing anti-arbitration injunctions and related issues, such as the grant of anti-suit injunctions by arbitral tribunals. We look forward to seeing you again then. Do keep an eye out for the invitation, and we hope you've enjoyed today's seminar. Thanks very much.